Welcome to Intuitive Defense. My name is Baker. I want to take an opportunity and provide an update to the National Firearms Act, NFA, as it pertains to registration and enforcement action and how members of Congress are taking steps to ensure that our Second Amendment rights and freedoms are being preserved by pressuring the DOJ to take less enforcement action on certain unconstitutional laws. Before diving into the deep end of current information, I need to give a brief explanation of events leading up to where the NFA stands now, so be sure to stick around to the end of the video for a full wrap-up. If you don't know, the NFA, National Firearms Act of 1934, is a taxation of certain firearms-related items like suppressors, short-barrel rifles, and short-barrel shotguns. If you want to own a suppressor or an SBR, short-barrel rifle, you have to ask Uncle Sam for permission because these items are simply just too dangerous for you to own, unless of course you pay money to the government, which makes everything safer. Hooray for safety through taxation. The excise tax imposed is $200 per NFA item in today's money. In 1934, it was the equivalent of about $4,800. The purpose was to make these items so expensive the common, law-abiding person could not afford them. Hooray for safety through classism. On July 4th of this year, 2025, President Trump signed the One Big Beautiful Bill Act, OBBBA, into law. One of the topics addressed in this bill was the NFA tax on suppressors and SBRs. The One Big Beautiful Bill Act dropped the $200 NFA tax to $0. Although this is a win in terms of not having to pay the government money to use a right, it isn't really a win because those items are still controlled by the NFA. There just isn't any tax collected on them once this bill takes effect January 1st, 2026. As it stands now though, at some point down the road, anti-2A politicians can work to bring back the NFA tax and make it even more expensive. Proof of this is with the actions from Senator Chris Murphy from Connecticut, who just a few months ago put forth an amendment, SA 2973, to Bill HR 3944, which would reimpose a tax on NFA-regulated items, and adjusted for inflation would be a cost of $4,709 per NFA item. This is just the tax amount. When you factor in the suppressor cost, it could be near $6,000 for a suppressor and the permission slip to own one. Actions like that is just the reason why suppressors and SBRs need to be removed from the NFA completely. Thankfully, there is a path available that could make this a reality. One such path is removing said items because there is no longer a tax collected on them. In 1937, the U.S. Supreme Court stated a challenge to the NFA stood constitutionally because it wasn't a regulation but a tax collected on certain items. Therefore, it can stand. Now that the tax is $0, is it still constitutional? I don't think so. But this is the direction and question a very pro-2A politician is moving in. On November 10th of this year, 2025, Congressman Andrew Clyde sent a letter to Attorney General Pam Bondi. In this letter, he addresses constitutional worries that the DOJ will take registration and enforcement action against NFA-controlled items like suppressors and SBRs, even though the tax collected will be $0 come January. I'm not going to read the entire letter to you, but I want to focus on the last few paragraphs of the second page. Following the OBBBA's elimination of the tax on a broad class of firearms registered under the NFA, the constitutional foundation for applying the NFA's transfer and registration requirements to those $0 tax firearms no longer exists. These requirements now operate without any corresponding exercise of Congress's taxing power, as the Supreme Court upheld the NFA's provisions only as in aid of that power, and since the relevant excise tax have been repealed, the transfer and registration requirements should likewise be understood as repealed with respect to firearms now subject to a $0 tax. As members of Congress who supported the One Big Beautiful Bill Act and participated in the legislative process surrounding Section 70436 of that act, we wish to reaffirm that it was our intent in enacting Section 70436 to repeal the transfer and registration requirements under the National Firearms Act by eliminating the associated excise tax for certain firearms. It remains our clear intent that these transfer and registration requirements shall no longer apply to firearms now subject to a $0 tax for the reasons outlined above. Accordingly, We urge the Department of Justice to adopt the position of the drafters of this provision that the transfer and registration requirements cannot stand without the corresponding excise tax. We further urge the Department to assert this position in all litigation concerning this specific section of the OBBBA. President Trump has been the most pro-Second Amendment president in our nation's history, and the Department of Justice has an opportunity to uphold his strong record of protecting gun owners from burdensome regulations. Thank you for your attention to this important matter. We look forward to working with the Department of Justice to advance additional pro-Second Amendment policies. It's pretty clear on what he, along with the 30 other pro-Second Amendment members of Congress who signed this letter, are requesting. Since the tax is set at $0 for certain NFA-controlled items, those items should not be applicable to the NFA regulations and restrictions anymore. As such, there is no constitutional authority for the government to take any actions on said items as they are no longer bound by the NFA, meaning people who can lawfully own and possess firearms should be able to own and possess suppressors, short-barrel rifles, short-barrel shotguns, and other weapons without any additional approval from the government. If you want to go buy a new suppressor for your new short-barrel rifle, you should be able to do so without needing to Form 1 them, which is the current ATF form that you need to fill out right now. Not only would this restore part of your Second Amendment rights and freedoms by removing these items from the NFA completely, but it makes it more difficult for POS anti-Second Amendment politicians to infringe on our rights and freedoms later on. Once these items are removed from NFA control and more people are able to more easily purchase them, they become even more of a common use item than they already are, which is good for us as demonstrated in the District of Columbia versus Heller decision in 2008. The common use test establishes that the Second Amendment protects arms that are in common use at the time for lawful purposes like self-defense. Weapons meeting this standard generally cannot be banned by the government. Rifles, pistols, shotguns, and other types of self-defense items receive protection through common use. Although I personally believe there are more than enough suppressors and SBRs currently owned by law-abiding citizens that constitute common use, if and when they are removed from the NFA entirely, there will be an even larger footprint of common use items helping to solidify protection from anti-gun, anti-Second Amendment politicians and legislation in the future. All in all, the $0 tax on certain NFA items is an important step in the right direction, but it can't be the last step. Thankfully, we have individuals like Congressman Andrew Clyde who are putting on their running shoes and making sure that rights and freedoms are being protected from government infringement by taking the steps necessary to make it more difficult for government to trample people. Well, that's it for me, folks. I just wanted to provide this current event update. If you found this information beneficial, please consider subscribing to our channel. Also, let us know in the comment section below what your thoughts are on this topic. Do you think DOJ and Attorney General Pam Bondi will do what's right for the people? Or do you think government overreach will win again? Let us know down below. Thank you and have a great day. We'll see you in the next video.